Me now is Ronald Chapman. He is a federal criminal defense trial attorney. Ronald, thank you so much for your time today. You just heard Ava Joy. They're talking about defendants that are now turning themselves in. They're surrendering. So take us through what's going to happen in terms of the booking process. It seems to me that the process has been going rather quickly. But what do you know about what will take place? Will they be fingerprinted? Do they need to take a mugshot? Will we see a mugshot of former President Trump?
All wonderful questions. And let me tell you, this is going to be a Herculean effort by the staff there in Fulton County. It's going to be difficult to process all of these 19 people. While I'm sure those professionals do it every day, we have some high profile individuals coming in all in rapid succession. So let's walk through the process. First things first, attorneys will normally negotiate, just as Trump did, the bond conditions. He was able to negotiate $200,000 worth of bond. It was approved by the judge. They'll also negotiate the timing of surrender. I have a feeling that schedule has already been worked out for just about every one of these 19 people. The defendant arrives at the jail. Normally there's fingerprinting taken. There may be even a DNA swab in some cases. There may also be a mugshot taken. Unclear whether or not Trump is going to have a mugshot taken. I know that I don't believe happened in New York. I'm not so sure that it'll happen here, but there likely will be mugshots of the other defendants in this case. After that, normally they would be released. I heard some mention that Rudy Giuliani is having some financial difficulty. I think there's no chance he's actually detained in a jail pending trial in this case. He'll come up with the bond one way or another, and then everybody will proceed to trial and review the discovery in this case.
I wanted to ask you about certain bond requirements, because I do know that the judge is asking the defendants to participate in certain ways. For example, part of Trump's bond essentially is that he can't go after any witnesses on social media. He can't intimidate co-defendants, witnesses. So, Ronald, what happens if he does? I mean, how does the court address this? Is there a punishment?
Well, the court has set standard bond conditions like they would in any case, and I would expect that all defendants would be prevented from threatening other witnesses. In fact, there's United States Code which actually prevents that, so it's a separate criminal offense. But if a defendant violates their bond conditions, if they use drugs and they're not supposed to, if they threaten a witness and they're not supposed to, there would be notice of that violation sent to the court. Then the court would have the opportunity to have a hearing, and at that hearing, the question is asked, did that person commit a violation, and what should the judge do about it? Now, throwing somebody in jail until trial is not usually the first thing judges do. Usually the first thing they do is try to address the specific conduct, make sure that it doesn't happen again, to continue the case moving forward. All judges know that putting somebody in custody, especially for a trial as big as this, really impedes the ability for the trial to move along in a speedy manner, and it impacts the ability to deliver justice. So I don't think anybody's going to get detained. I also, think that if Trump flagrantly violates this bond condition, he will have to go before a judge and have a hearing on that, and there will be some sort of punishment for that conduct.
And this is going to be a tough one for him, because it is really hard for him to stay off of social media. As we can see, he has been really in control of the narrative all the way through. But there are a handful of witnesses that have turned themselves in. So what comes next? Trump has said that he's going to turn himself in on Thursday. What more can we expect to see in this case?
So after everybody's turned in, there's likely going to be an initial appearance, which usually involves scheduling. Now, we know that the prosecutor wants this case to go very quickly and end before the election. I've said before, even on this network, I don't think there's a chance of that happening. This is a very complicated indictment, a lot of individuals charged, and unless a lot of people are pleading quickly, this case is going to take a while. So the DA now has to produce all of the discovery they have from their investigation onto the defendants. Their attorneys will start reviewing that information, file pretrial motions, and prepare their witnesses for trial. I can expect that the Trump team will probably try some delay tactics, some motions, or raise evidentiary issues in order to delay this case further. And we also have, I think, John Eastman publicly indicating recently, he seems to be fully in the Trump corner, already raising some of those defenses. So I think that there's a likelihood that a lot of these 19 people actually end up in a trial which means this is going to be very difficult to get done quickly.
All right, Ronald Chapman, federal criminal defense trial attorney. We appreciate your time today. Thank you so much.
Thank you.
So to come on Scripps.